We all have gathered here to discuss on scenario in Jammu, post-abrogation of Article 370 in light of Honorable Supreme Court judgment. So without a further ado, let's dive right into the very heart of the seminar. So I invite Venerable Shri K.V. Jandal, IAS retired, to take the stage and grace us with his knowledge.
Good evening. Dignitaries on the dais and galaxy of Jammu city and of the dais. It's my profound pride and privilege to be participating in this seminar on Article 370, abrogation of Article 370 and the judgment of the Supreme Court on the Article 370. Friends, both things, abrogation within courts of Article 370 and the landmark judgment of the Supreme Court on the 11th of December 2023 are the landmark and historic one. It's a watershed movement for people of Jammu and Kashmir in different ways. In fact, there were many constitutional and legal myths relating to Article 370. And there have been a lot of expectations in Kashmir on the abrogation of Article 370. I would call both the things as again a myth. Article 370 does not give or does not restrain us from achieving anything when it was in existence. I said abrogation within courts. I personally feel, though even the Supreme Court judgment also mentioned abrogation. I don't think it is an abrogation. It's a constitutional reframing of the article. Because the Article 370 still exists. It has not gone. A new text has come into being. So when you talk abrogation of Article 370, there is no Article 370, but the fact is that it is still in the Constitution of India and it is very much here. When I started with the saying that there were many myths about the constitutional myths about Article 370 and even the abrogation. Most of legal luminaries and constitutional experts, and including I also subscribe to this view, that 5th August 2019, when the bill was introduced in the Parliament, I described it as constitutional innovation. According to my limited, I'm basically a student of constitutional law. I'm holding the degree of LLB, but I'm not a practitioner of law as such. But I had interest in Article 370, so that's why I keep reading and writing on that. The constitutional myth I described at that point of time, I wrote in the article, state talk in Excelsior. By substituting the Constituent Assembly of Jammu and Kashmir that exists in the proviso of Article 370, clause 3. According to our perception, legal perception, the President of India was bound by the recommendation of the Constituent Assembly as it exists in the proviso of Article 370, clause 3. And to get rid of this problem, the Government of India sorry, not the government of India, but the President of India, invoking powers from the Article 370 itself, substituted the word Constituent Assembly of Jammu and Kashmir in the proviso with Legislative Assembly of the state. This change was incorporated in Article 367. When the word of the Constituent Assembly was substituted by the Legislative Assembly, and on the 5th August 2019, the state was under president rule. And under Article 356, when the president rule is promulgated, the legislative powers of the state, which is brought under the president rule, goes to the parliament. So, parliament became the legislative assembly of Jammu and Kashmir. Legislative assembly was subsumed the Constituent Assembly. So, a recommendation from the parliament, as you say, it is a legislative assembly of Jammu and Kashmir, to change the law, change the text of the law. This was, according to me and like many of us, is a constitutional innovation which nobody thought of it. Just to tell you that Article 367 is an article of interpretations. The Constitution has one article which talks about the interpretation. Now this myth was broken by the Supreme Court in its judgment, 11th December 2023. It said, President has no power to modify the Article 367, to modify 370 by using the Article 367 of the interpretation. And as such, the constitutional order of the President, 272, particularly para 2nd of the 272, was struck down. So entire thing has collapsed according to our perception that it has substituted the word of the Constituent Assembly with the State Assembly, and then State Assembly, the powers were with the Parliament at that point of time. But this judgment, I said it's a landmark historic judgment, it again removed a myth from us that President otherwise had no power to abrogate it because of proviso. But the judgment, the majority judgment, 3 judges, and also the 2 judges who wrote separately, Justice Kaul and Justice Khanna, Sanjeev Khanna, they also corroborated the power. The President have absolute power to change the Article 370 irrespective of this recommendation. He was not bound by the legislature because the Constituent Assembly does not exist. But does it mean that it does not exist? The article has become permanent. So President cannot change it. So it settles the law, the thing doing, the President had otherwise power. Because the non-existence of Constituent Assembly does not make the law, make the Article 370 permanent, and as such, the President, by his constitutional order of 273, is has absolute power to extend all the provisions of the Article 370 to Jammu and Kashmir without changes, without modification and exceptions. The word the exception and modification is figuring in the Article 370, where probably Article 370 Clause 2. It says that President, on the recommendation, in consultation with the government of the state, can extend the provisions of the Constitution of India to Jammu and Kashmir with exceptions and modifications. The actual spirit was that you cannot modify the Constitution of India, while applying to Jammu and Kashmir, you can modify it. You can take some exception, comma, you can delete a word, you can delete a sentence, but the spirit of the article shall remain same. That was the idea of keeping the word like exceptions and modifications. Now, when the President under Constitutional Order of 273 extended entire Constitution of India to Jammu and Kashmir, it was as amended from time to time, but it was not with exceptions or modifications. So the Supreme Court has upheld the President of India's power, which all of us, most of us, we have not heard anywhere in any debate or any seminar that President can do it without recommendation of anyone. So this is one myth, second myth which has been removed. One was, and second is that the Supreme Court, the judges have gone in detail the historical background of Article 370. We normally accuse Sheikh Abdullah and Pandit Nehru of manipulating this Article 370, but they have not touched that part of it. But they said it was done because of the war situation in Jammu and Kashmir at that point of time. And the process of this whole thing was fluid, so let's have the Article 370 to govern the Jammu and Kashmir with the parameter of the spirit of the Indian Constitution when it was promulgated in January 26, 1950. Now, the judgment, the Chief Justice of India, Dr. Chandra, he is the author of the main judgment. He argued that the very fact that this article has been placed under the subheading of the chapter, temporary provisions. So that is the crux of the situation. It has not attained permanency because it has been placed there, and with the situation prevailing in Jammu and Kashmir, it has not decided, taken a final view on that. So it continues to be a temporary article provision, and there is no question of it is becoming permanent because it has now passed 70 years. Another part which I like to mention before you is that now, what is the fallout of? Normally we say fallout of the Article 370, whether when it was in existence or after the abrogation. Justice Chandrachud says that whenever the President of India exercised the power under Article 370 and issued presidential order, which is normally called in the Constitution as a constitutional order, CO, from time to time. There are changes, nomenclature of the Prime Minister to Chief Minister. 80-90% Constitution was extended to Jammu and Kashmir by virtue of these COs, constitutional orders. He says this indicates the gradual process of constitutional integration which was going on since long. The constitutional integration of Jammu and Kashmir with Union of India was going on right from the beginning, when the President has been using the power under Article 370 and issuing COs, extending one provision or the second provision of the Constitution of India to Jammu and Kashmir. For your information, when Article 370 was incorporated, only two articles were extended to JNK. It has gone automatically. One was the Article 1, India, that is Bharat, is a union of states. And Jammu and Kashmir was one of the B category state, so it was a part of that. And second was the Article 370. So remaining articles were extended with modification and exception by the President through COs, by constitutional order, or with the consultation of the state government. So, this by on 5th August 2019, it was entire Constitution of India, as modified from time to time, was extended to J&K. So we became the beneficiary of the progressive laws of the country, and the people of Jammu and Kashmir were not deprived of any law. Again, for your information, when the Constitution was adopted and it was promulgated in India, J&K was the only state where we didn't have the fundamental rights. Chapter 3. It was extended with modification and exception after Sheikh was ousted, after 53. So, when it was only two articles were extended, so it means people of Jammu and Kashmir were deprived of the basic rights, basic fundamental rights, and we are not talking about the freedom and of speech and expression and all sorts of things, but at that point on, we were not given that right, this freedom. Another, I won't call a myth, but is a impression, and most of the people write and still speak, that we have a separate constitution of Jammu and Kashmir. When entire constitution of India was extended in entirety, in totality, what has happened to the J&K constitution? It was in existence, whatever worth it had, but it was a constitution made by the Constituent Assembly of Jammu and Kashmir, which had the sanctity of the government of India. You can have the constitution separate. It was normal impression that this constitution has also gone. I was one of the few people who said no, it has not gone. Why? When you read the Article 370, which replaced the earlier one, it mentioned, I will just read it for your information. It mentioned that all provisions of the Constitution as amended from time to time, without any modification or exception, shall apply to Jammu and Kashmir, notwithstanding anything contrary contained in the Article 122, 152 or Article 308 or any article of this Constitution or any other provision of the Constitution of Jammu and Kashmir. By writing this in the present text, it corroborated that this Constitution is in existence. But now the judgment says it has become inoperative by virtue of extension of the Constitution of India in totality and has become redundant. But it remains on the statute. It has not been repealed by the Parliament, not even repealed under the J&K Reorganization Act or by any other constitutional authority. The Constitution of Jammu and Kashmir remains, but it has become redundant. Having said so, it is a historic judgment. It has belied most of our myths and perceptions which were wrong. Because we said it cannot be changed. In fact, it was thrown out of the window of the Parliament on 5th August. The one issue on which Supreme Court judgment can be criticized, including I also criticize for that matter. That issue is of not adjudicating the matter relating to downgrading of Jammu and Kashmir to a union territory. They preferred to put it in the back burner taking a plea that the Solicitor General of India has made a statement before the court that statehood will be restored soon. And they recorded it. They recorded it in the judgment, the concluding part of that. Now, the question arises why I am raising this issue as a legal issue. Advocates are better. The Solicitor General of India represents whom? He represents the Union of India, the Government of India. Nobody can represent the Parliament. And the change of the status of any area, it's the first time that the state has been downgraded, but otherwise the union territory or the state is divided, bifurcated. But the procedure for that, the constitutional procedure is given in the Article 3 of the Constitution of India. And that one part of that is that the president has to refer this proposal or motion to the concerned legislative assembly of the state. The legislative assembly was not in existence at that point of time. Now the judges say, since it was not in existence, and moreover, right, the recommendation of the legislative assembly on the issue of statehood or otherwise is not mandatory, is only recommendatory in nature. So merely because it's recommendatory, so we do not adjudicate this issue. And we go by the statement of the Solicitor General of India, who does not represent the Parliament, and it's a prerogative of the Prime President of, it's a prerogative of the Parliament to decide. The government only moves the bill. The decision is taken by the member of the Parliament, not by the government. How can you say that it is bound to be adopted? So it will be a violation of the privilege of the members of the Parliament to say so, that before even discussion, they have decided that the Parliament will pass this bill. On this issue, not only we, but many jurists and legal luminaries have been criticizing the judgment that it should not have put on the back burner and they should have decided the issue. And then they, while there is a specific direction to hold elections by 30th September, it had left it as vague, saying that resolution of statehood shall take place at the earliest and as soon as possible. So no time frame is given. It is left to the Union of India to decide this issue. This is about the judgment and the Article 370. Of course, coming to the question of Jammu. How Jammu is affected and what expectation Jammu or for anybody has of the abrogation of Article. We were part of the India here also. The process of constitutional integration was going on. Otherwise also the process of integration with the rest of the country was going on. We have been going out, we have been living outside, people have been coming here, they have been doing business here. So integration was going on. Now, one part is that you cannot say that we are constitutionally integrated. That is there's a final, it culminated. The 5th August was the culmination of that process of constitutional integration. When the entire constitution was extended to Jammu and Kashmir. But there was the emotional integration. The emotional integration was with Jammu and Kashmir and the rest of the country. Notwithstanding, we were already Indians. We were already integrated with the rest of the country. Our members have been taking part in the parliament, deciding the issues of the country. So that was there. Now we were all the people of Jammu and Kashmir, have been happy because we have emotional barriers have been removed. Exploitation of this article is removed. More than the emotional integration, it is the exploitation of Article 370 by saying that we have a separate flag, we have a separate constitution, we have a separate nation. That is this has gone forever for that matter. So that is the biggest advantage for us in Jammu or Kashmir, or particularly Jammu. Now, if we are looking forward, that if the article 370 is abrogated or removed, something will come here. What something will come here? Nothing. The one thing is that it is possible that now the investment is possible. And investment possible more in Jammu than Kashmir, because Kashmir continues to be hostile land. No person wants to invest in an area which is hostile. So the choice of investment will all fall in Jammu region. So that could be economic benefit which will come gradually. It is not that an article gone and investment comes. It takes time. Everything takes time. Second is the reservation which people are now having in Jammu. People keep asking, हमें क्या मिला जी? वो हम लुट गए जी, हमें कुछ मिला ही नहीं. इस तरह से क्या हुआ? नौकरी बाहर से नौकरी वाले आ जाएंगे, वो आ जाएंगे, ये आ जाएंगे, blah blah. When I can go and compete in UP or Haryana and Punjab and Delhi, why can't the other people can compete here also? It's a normal phenomenon. But even if, let's say, we want special rights, the domicile is there now. Domicile is there, so it is restrict. And if you say some category of people have been allowed to become the state subject or domicile, you forget that the state subject provision order of Maharaja Hari Singh also says so. Ijazatnama, and it was there. It can be possible to get a state subject by non-state subject people by Ijazatnama or Iqrarnama. After 10 years of your residence here, the people can apply and get the state subject. So that Sani Saab is one who was in Srinagar. He is a very renowned journalist also. Satpal Sani, Sati Sani is popularly known as Sati. So, domicile, that clause of state subject, 10 years, which was not permitted in a post-independent Jammu Kashmir, even though it was mentioned in the J&K Constitution. Section 5 to 10, which refers to the, I'm talking about the state constitution, it refers to the state subjects. And one of the sections, the last section was that, which even once the Sheikh Abdullah also called 370, कोई खुदाई किताब नहीं है, ये बदल नहीं सकती, खुदाई किताब नहीं है. It says the legislative assembly, the legislature rather, legislature can change the norms for the state subjects. If the Kashmir dominated political parties and the governing ruling parties at that point in time have given little thought to it and included the Safai Karamcharis which were brought from Punjab to Amritsar to here, or other category, Gorkha and different things, small, even West Pakistani refugees, the hue and cry would not have been there. It is only that the Article 35A, which is normally is not the subject matter, but so it was provision. So domicile carries that provision also. that if you are living here for 10 years or you are, it's a very simple thing. Khudasa will bail me out. Any IAS officer who was allotted here as J&K cadre as a state has been serving here for 40 years, 30 years, and he is totally detached from his roots, from wherever he has come. And he is not allowed to stay here. He is not allowed to own a house. That is a very unfair thing. So that they have rectified it, that those who are serving here for such a long time, they can get the domicile. And Naveen was the first to get this domicile certificate, and he showed it in a picture, and a lot of hue and cry, "Ye bahar wale aage, yahan par aage bas gaye." So that is one other part that we were expecting it to happen, which did not happen, and that's why our reservation about the हमें कुछ मिला नहीं 370 के जाने के बाद. 370 does not give anything else. I don't subscribe that is again a political domain to talk. Such a huge investment has come, such a huge landmark projects have come out, AIMS, IIM, all different things, roads and everything. But I take it to view, it's a duty of the central government to do all these things for every state. I don't link this, the bonanza, economic bonanza which the Modi government is giving to us in J&K. It is not linked with should not be linked with the abrogation of Article 370. The Article 370 does not restrict this type of development in Jammu and Kashmir. Every government should and has been giving it, I think, little bit. Even Manmohan Singh had announced a package of 90,000 crore. But yet that's a different story. It was not spent, even though 20% of that was not spent during his time. That's a different issue. But we are unnecessarily attaching different things to abrogation of Article 370. To me, it is, we have become as good citizen or as a full-fledged citizen of India as any other part of the country. That emotional touch is there. We are not a separate nation. We are not separate class. We are as Indian as anyone else here. So don't expect anything and don't criticize the abrogation of Article 370 merely because we have not got it. We will get out of our merit. Not a charity. Why should we get a charity for that matter? Those classes who are, economically or socially deprived or have a OBC and other things, SC, STs, they are entitled to certain provisions which the Constitution of India provides. They protect their rights and they will get it here. Like for example, this Kashmir J&K government have never thought of giving a political reservation to STs. They have given it. It is already in the part of the Constitution of India. The seats have to be reserved. They did not reserve it. That's another follies of our previous governments. They deprived them. But because the entire constitution has now been extended to J&K, so these things will automatically flow. The provisions of the Constitution of India will flow automatically to Jammu and Kashmir, and all these things are coming. For example, Amendment 73 and 74, all Kashmir government has restricted it. They resisted that will not implement, will implement part of it. Some part here. So it comes in totally, all the panchayats and civic bodies have become empowered. And I had a fortune of serving the Jammu municipality for 2 times. We had no resources. Ajay is sitting here with me. He was with me. We were together at one point of time. हम 5 रुपए रेडी से इकट्ठा करके काम चलाने की कोशिश करते थे. 5 रुपए 99 अजय 99 5 रुपए. और मुझे कहते थे कि ये 5 में से 3 रुपए तो वो कलेक्शन वाला खा जाएगा. मतलब 2 रुपए मिलेंगे हमें. चलो, that was the issue. We hardly had 4 or 5 vehicles. Today there is no limit. The fleet you see, it is only because the Article 3, the amendment, the Constitutional Amendment 73 and 74 has been extended, and a huge money from the government of India. Because unless you follow that pattern, the government of India was not giving the money. So it automatically flowed. That has the advantage. Don't look for advantage from person, me, Pradeep, Ajay. Don't look at it. Look at it as a whole, as a unit. The Jammu will also get its share, and so is the Kashmir. Let's not compare Jammu and Kashmir this right? Because now that comparison and discrimination should be thrown out of the window. Look for yourself to whatever is available under the constitution and the law. We should follow it. Thank you very much, sir. I tried to cover as much as possible. Thank you.
Thank you so much, sir, for your valuable information.